Good morning and a warm welcome to the 22nd meeting of the Education and Skills Committee. Can I remind everyone to turn mobile phones to silent during the duration. Our first agenda item is to decide whether to take agenda items 3 and 4 in private. Does anyone object? Thank you, committee. Our second agenda item is redress for survivors historical child abuse and care Scotland Bill evidence session, and we welcome to committee this morning Donald Henderson, Deputy Director, Paul Beaton, Unit Head, and Lisa McCloy, Bill Team Leader, all from Redress Relations and Response Division, and Barry McCaffrey, Lawyer, Scottish Government, Legal Directorate of the Scottish Government. We're not going to have an opening statement from the team this morning, and we're going to move directly to committee questions. I would now like to invite Daniel Johnson to open.
Thank you, convener. I'm sure the Bill team will agree that ultimately, for this to be successful, we need to ensure that the right decisions are made for the right reasons and done so in the right way. But as it stands, it's very difficult to have confidence that will be the case, because the bill does not set out the criteria or the process. It leaves that to guidance. I was just wondering what the bill team's reflections are on that, and what we should expect to come forward with regard to these matters.
Mr. Henderson, do you want to open?
Yes, thank you very much, convener. Thank you, Mr. Johnson. As you know, the bill sets out at high level the factors that need to be taken into account by Redress Scotland in making awards, but there is more detail that needs to be fleshed out, and we would expect before the end of the first stage proceedings to have material with you to allow the Parliament to step beyond the high-level principles set out in the bill. It is, as you started your question, it is absolutely vital that this work is done right. One of the things that we are trying to do in redress is not only make redress payments, it is addressing the failures that society over many decades made in allowing the abuse to happen and persist, but also in the treatment of too many survivors afterwards, where they have felt ignored and belittled by society. And if we don't have a scheme that addresses their needs, including in terms of the assessment framework, then we're not going to have achieved our aim. So undoubtedly more detail needed, and we would aim to have it with you certainly before the end of first stage.
Mr. Johnson?
The only criteria that I understand is currently in the bill is that the decisions must have nature to regard to the nature of the severity, frequency and duration of the abuse. There's no mention of the consequences, costs, or the wider social impacts, nor is there any requirement for it to have regard to whether or not these incidents could have or should have been avoided. These are clearly things that at the very least require clarification, but I would wonder why these high-level principles aren't on the face of the bill.
Well, the bill is intending to pick up activity, crimes that should not have been going on in the first place. So we're not trying to deal with activity which was perfectly legal and perfectly acceptable at the time. We're not designing a scheme here which is intended to replace the civil courts. The civil courts have a place to assess ongoing impacts in terms of, for instance, loss of earnings. That isn't a part of the redress scheme. What we're looking at is the abuse that took place in terms, as you say, as outlined, of the nature, the frequency, etc. And the guidance that we produce and the work that we're doing with psychologists who are advising us and that we will discuss with survivors as well, will flesh out those high-level principles so that we can build the approach that Redress Scotland will assess in looking at individual applications and the circumstances behind each individual application to settle on an award level.
And just finally, given the quite broad scope that Redress Scotland is going to have to develop its own assessment processes and indeed criteria, even given the guidance that you've set out, would it not be a good idea to have an independent chair, a chair separate from the chief executive? Whereas I understand, the bill as set out combines those two roles. Is good governance not absolutely critical given the scope that Redress will have?
I certainly agree. Good governance is critical. Alongside that, the independence from government is critical as well, which is why we've we've protected Redress Scotland from any ministerial from ministers having any involvement in the decisions on individual applications. Now, in order to set the scheme up quickly, we're proposing to do the administration within Scottish Government, and basically that bit of Scottish Government is instructed by Redress Scotland as to what to do. That has meant that Redress Scotland itself will be very small. The bulk of the staffing work will actually continue to be done within Scottish Government. But it's a point that we can perhaps continue to talk about. Our conclusion was that because Redress Scotland was so small, that having a separate chief executive and a separate chair was not the right approach. But that's one that there will be other views, and we will absolutely learn and listen from them.
I'm not sure I understand why scale alters requirements for good governance, but I'll leave it there.
Okay, thank you, Daniel. Can we move to Beatrice Wishart to be followed by Mr. Gray?
Thank you, Convener, and good morning, panel. My connection dropped out briefly, so I hope I'm not actually going to be repeating the questions that Daniel has asked. I don't think I will be. My questions are around the applicants with convictions for serious criminal offences. And there are differing views that compensation will not be awarded to a survivor who has a criminal record for a significant offence. So given what we know now about unresolved childhood trauma and how that can lead to offending behaviour, what account was taken of this in the decision not to offer redress payment, where it would be contrary to the public interest due to the applicant having been convicted of a serious criminal offence and someone who has been sentenced to imprisonment for a term of 5 years or more?
Hi, thank you. Can everyone hear me? Sorry, I'm not sure. Yeah, thank you. Yeah, it's a really good question, and we recognise that this is a very difficult and a very sensitive aspect of the bill, and we know that there are strongly held and varied and opposing views on this, and we have listened to those throughout the consultation, and we will continue to listen to the evidence that the committee hears on this aspect of the bill. What we've done in the bill is we've set out what we think is a proportionate response to an incredibly complex issue, and it's important to note that there's no blanket presumption or exclusion within the bill to prevent redress payments being made to people with criminal convictions or with serious criminal convictions. But in acknowledgement of the concern of some for the use of redress payments, which are obviously in respect of abuse, going to those who have gone on to commit very serious crimes, particularly abusive crimes of abuse, the bill takes the position that the independent decision makers of Redress Scotland will have an opportunity to look at cases on a case-by-case basis, to look to see whether there is a public interest argument to not make a redress payment in those cases. The bar is set deliberately high, and it will only be triggered where applicants have convictions for murder, for rape, or for serious sexual or violent offences for which they've received a sentence of imprisonment of 5 years or more. I would emphasise that there's no presumption, there's no blanket exclusion. Applicants would have a right to review decisions made by Redress Scotland, by the independent decision-making body. And the other matter to note that is that applicants with very serious previous convictions would still be eligible for elements of non-financial redress offered by the scheme.
I thank you for that. And turning to actually now the support for applicants and legal advice. So how will support work in practice for payment for applicants in terms of their legal fees, and how they might incur costs in trying to find the evidence? How would it actually work in practice?
Yeah, so we recognise that support is an important aspect of any redress scheme. We recognise that some applicants will want support, and that will vary. The support available will vary according to what the applicant needs or what the applicant wants assistance with. We recognise that there's obligations to make sure the scheme is as accessible as possible, and we're working with partners to make sure we have information that's in accessible formats and so on. But we also recognise that applicants may require practical support to apply for redress. That may involve support to access records. But another important aspect of the scheme is that we recognise that survivors may require emotional support to apply to the scheme, because applying to redress may, for some, there's the potential for it to be re-triggering difficult aspects of a survivor's past. So there will be emotional support there to assist survivors who are confronting these aspects of their past. In terms of the legal, we understand that some applicants will want legal advice from the outset, but I think it's important to note that we're trying to design a scheme where that will not be necessary for applicants. There will be a point in the scheme, for a survivor in their application, where we will strongly encourage advice is given before the acceptance of a payment, and that's in relation to the signing of a waiver, which we may come on to separately. But just to focus on the provision and the funding of legal advice just now, what we've done is we've looked at what's happened in other schemes, and we're aware that legal fees can really escalate in some redress schemes. And that's not something that we want for this scheme, because we want the majority of the money to go to survivors, but we do respect that there is a need for independent legal advice. So what we're proposing is for ceiling limits or caps to be placed on that legal advice in order to try and control the legal expenses of this scheme. However, we do recognise that there will be cases which are more complex than perhaps the fee would allow for, so there is mechanism within the bill for solicitors to apply to exceed those ceilings, and there's also mechanism to review decisions on whether to allow somebody to exceed those fees or not.
Thank you for that. Thank you, Convener.
Thank you. Can we move to Mr. Gray to be followed by Mr. Neal?
Hello.
Dean.
Hi, thank you, Convener. Could I ask about the waiver? The bill means that those survivors who avail themselves of the redress scheme will have to sign a waiver giving up their rights to pursue compensation in the civil courts. Can the bill team see, when the Cabinet Secretary introduced the bill in Parliament, he made it very clear that the reason for this was to encourage, so as an incentive, to those institutions responsible for historic abuse to contribute to the fund from which redress would be paid. So can the bill team see that from the point of view of survivors, it would appear that the interests of the institutions responsible for their abuse will have been put ahead of their interest.
Perhaps it might be helpful if I set out a little about how what the waiver is designed to offer for survivors as well as for providers. Essentially, the scheme proposed in the bill really looks to create a national collective endeavour, which does encourage those, as you say, who may be responsible for abuse in the past, to step forward to acknowledge and respond to survivors in a way which doesn't require them to go to court, and it is designed to act as a choice for survivors whether they would prefer to pursue litigation or proceed through redress. It's not a choice available to all, but for the majority it would be. Through previous consultation, previous work with survivors, it's been made very clear that contributions from organisations are a really important part of the scheme acting in that collective way, and the waiver is the most effective way of achieving that. It's been used in the majority of redress schemes worldwide, particularly where contributions are in play. There should be, I think, no suggestion that the operation of the waiver can act in a way to silence survivors. Those who prefer their day in court can absolutely proceed on that basis. But there's no sense of participation in the redress scheme, including anything like a non-disclosure agreement. Participation doesn't require. It doesn't stop survivors from discussing their experience either privately or publicly. The decision on whether to accept a redress payment, we've just touched upon independent legal advice, and that waiver will be signed only at the end of the process, only once the survivor is clear what the proposal from Redress Scotland is to be, and the organisations to which the waiver will apply. And I think as part of that national collective endeavour, it's fair to acknowledge those organisations who find a way to play their part in this. It's appropriate in encouraging them to do so that they have the opportunity to fund payments to survivors, to offer that sense of acceptance and participation, and as I say, to face up to their historical legacy as part of that national endeavour, rather than requiring survivors to receive that through another mechanism. But absolutely, we know that there are variable views on this, and it's a matter which has been given really very careful consideration as we've looked to develop the bill, and we'll continue to listen very closely to the evidence as it comes forward in the coming weeks, and happy to take, of course, any follow-up questions on that. It is a crucial matter.
Okay, thanks. If I may, convener, I think we all understand that survivors wish to see these institutions playing their part in contributing to the redress fund, but I think that they want them to do that because of their historic guilt, rather than as a good financial option on their part. Which is really the argument which has been put here. Can I come to one of the points that you made there? You said that survivors will be able to pursue the redress scheme and will only have to decide, once they know what the outcome of that process is, whether they accept that, and at that point then whether they sign their waiver. But of course, that's going to put survivors in an almost impossible position, isn't it? So in a hypothetical case where a survivor has been told that the redress scheme will award them the maximum, which is £80,000, they will then be put in a position where they have to decide whether they accept that as redress and give up their right to civil justice, or whether they reject that and then go to the civil courts, where of course they won't know what the outcome would be. They may feel that they have strong evidence and will receive a greater level of redress from the civil court, but they won't know that, of course, until they go through that process. Can you see that we are potentially putting survivors in a very difficult, perhaps impossible situation, making that decision at that point?
Well, I mean, I think you're absolutely right to highlight the uncertainty of the civil court process. It's true, and this redress scheme is very much designed for the majority of survivors. Completely accept that there will be survivors whose experience or evidence or preference may be to pursue that position in court, but that may not be the case for all. The redress scheme is designed to offer something different, and to exercise that choice. But you're right. You're absolutely right in what you say. There will be a choice at the end of the redress process, and there isn't certainty as to what may emerge from court at that stage.
Surely the way out of that dilemma is to allow survivors to pursue both routes. That's the way out of the dilemma. That's the interest of survivors here, isn't it?
Well, it would of course be possible to have a redress scheme which were to proceed on that basis. We have provision for legal advice as we've discussed, and also there's that point about contributions. I think it's if we're looking for organisations to, as I say, to step forward, to look to actively play their part in this, the existence and operation of the waiver within the scheme as designed is a really critical factor in respect of that. Now, it obviously wouldn't be for me to speak on the part of any organisations, but very clearly their considerations as to whether to participate, and if so, to what extent, are ongoing and are based on the scheme as designed. And I think it'll be a really interesting area of evidence and consideration as we go through the following weeks in respect of that. But there's no question that waiver is right at the top of the list that organisations are considering in whether to be part of this. Of course, I absolutely share the wish that organisations would want to play their part and would want to make contributions based on the historical legacy alone, and that may prove to be the case with some, but I wouldn't be as optimistic across the range of organisations that we're looking at here, representing 70 years of operation of the care system in Scotland.
Have these institutions
Sorry, Mr. Gray. Mr. Henderson wants to come in, and then I'm afraid we'll need to move on to the next member, who will be Jamie Green, followed by Alec Neil. Can I bring in Mr. Henderson on that point?
Yeah, thanks very much, Convener. It's just to emphasise that what we're doing, what the government's intentions here is, the estimation is that it's not possible to produce a redress scheme that will cater equally for the very small number of potential £1 million civil law cases and the enormous bulk of survivors who, if they were able to take a case at all, would end up at far lower settlement levels. So there will be people whose, on the basis of the legal advice and their own judgment, will get more in the civil courts, and we want to leave that choice for survivors as late as we possibly can in our process, and indeed to allow them to lead civil cases before and to conclude before they decide whether they find out whether they're successful or not. We're giving as much choice here to survivors who already have choice, but introducing a mechanism to survivors who can't bring civil litigation at all because they're pre-19, or who know that they have no evidence, difficult over past decades, or who know that they do have evidence, but the last thing they want to do is go through the kind of disclosure processes that are necessary in a civil case. So there will be some involved, but quite small numbers, and we're leaving their choice as late as we possibly can in the process.
Yeah, I'm going to move to Mr. Green before I look at Mr. Neil.
Thank you, Convener. Good morning, panel. I'm going to focus on the financial aspects of this. Can I start, perhaps more for the benefit of people watching this who haven't reviewed all of the documents that we have access to as MSPs, but could somebody outline what the estimated cost of setting up the scheme and the operation of it will be? First of all, what the ongoing cost of running it per annum would be, aside from the compensation money, and could the panel give some indication as to how they arrived at the projected forecast of the levels of compensation that will be paid out? What assumptions were made, what estimates were made, and how will that translate into reality when people start applying for the scheme? I appreciate we don't know how many people will apply, but surely some thought has gone into the potential cost of payouts once the scheme does open.
Mr. Henderson?
Thanks very much. I think my colleague Paul Beaton can go into some more of the detail there. Our overall estimate is 400 million for the scheme as a whole. But this is intensely, as you recognise, Mr. Green, in your question, this is intensely difficult territory to estimate final number of applicants that come forward, the average award that would be made, and in the quite considerable research that we've conducted over other schemes running internationally, we haven't found a single case where the initial estimates were right. In Ireland, for instance, and we've spoken to many of them, these were capable, accomplished civil servants in Ireland, but they were out by multiples in terms of their original estimates. We benefit from their experience, and we benefit from the experience of colleagues in other countries too. So 400 million is our central estimate, but there is inevitable wide uncertainty in that. On the detail of your question, Mr. Green, perhaps I can bring in my colleague, Mr. Beaton.
Mr. Beaton, thanks.
Thank you. Yes, the uncertainties that Donald mentions are live. We've tried to look as careful as we possibly can in respect of how many survivors may come forward to the scheme, and you'll see from the documentation that our central estimate is 11,000 potential applicants just now. But I think we would absolutely accept that will be inaccurate to one degree or another. And we will have to keep close watch on that. The way that we've done that is by considering the totality of those who were in care over the period covered by the scheme. So that's up to 2004 as in the bill as things stand. That's within living memory. That's perhaps 70 years of a care landscape which changed fundamentally a number of different times over that. We've worked with Scottish Government analytical colleagues and also with the Government Actuaries Department in London to try and understand what those numbers historically could mean, and the different sectors, organisations, institutions who were providing care over that time. There's some really good research about the numbers of children in care. Interestingly, a fairly consistent number of children in care, but in very different places by the end of the period rather than the beginning. So it is incredibly complicated.
Yeah.
The work we were able to do with the Actuaries Department, though, looking again at schemes elsewhere and the experience of our own advance payment scheme, which is now around 500 applications or so, gives us some really good information, particularly around I suppose the earlier part of the scheme. We've looked at the experience of schemes elsewhere in respect of their distribution of payment levels, and absolutely without any sense of an objective or target or anything like that. And again, we're very fortunate to have a very clear commitment that Redress Scotland will take independent decisions, and survivors will receive the payments decided upon through that process, rather than being subject to a more normal sense of financial drive, I suppose. So that's a really positive position to be in, but it really, I would say, exacerbates that uncertainty. We've looked.
Can I interject? Sorry, quite a lengthy answer, and I do have some supplementary questions, and we are quite curtailed in time.
One question, please, Jamie. Supplementary, one question. If you could wrap them together, please.
I will try, but they are really important matters, and unfortunately, my initial question wasn't really answered, Convener. So I do want to press on this, and I'm happy for this to come in writing if it's easier, because I appreciate there's a lot of detail in this. But I did ask a repetition. My first question was, what would be the setup and running costs of it, which are the fixed costs, which you must be able to estimate now, notwithstanding the levels of compensation that are given. But I'm slightly concerned by the answer around we don't really know, in the sense that other schemes have been massively out of kilter in their estimates. So what could the 400 million be easily be 800 million if 20,000 applications were given? And I guess the crux of my question is how much as a percentage of the compensation paid out will be paid out by the government as opposed to the institutions who will be contributing to the scheme, and have there been any indications as to the levels or caps on monies available from the institutions who will be participating in the scheme in terms of how much they will make available to pay in compensation?
Perhaps I can answer that element briefly, and I'll turn to Donald and Lisa in other respects. In respect of the programme costs, they are as set out in the financial memo in terms of the setup costs there and the ongoing programme costs. And as discussed in an earlier answer, the intention has been to provide a good balance of independence and efficiency in the setup to make sure that Redress Scotland has the right structure, the right decision-making powers, but without taking away from the primacy of payments to survivors. Now, again, I'll turn to others for other matters, but on the contributions point, those discussions are very much ongoing. The point about waiver, I think, bears repetition in and around whether organisations will find a way of participating in the scheme. But you're absolutely right. That issue about affordability is being raised, particularly with regard to the protection of current services. And as you know from the bill, we're working on a set of principles around fair and meaningful contributions to the scheme, which will look to take into account those things, because we're looking really around issues of transparency as well, and we want to make sure we get that right, because we don't want to do anything that unreasonably jeopardises the existence of organisation, and we certainly wouldn't wish the scheme to have an adverse effect on any vulnerable person today. But clearly we need to encourage significant contributions from organisations in the most effective way that we possibly can, and again, I think that's where waiver and the package as a whole really comes in. But I'll being conscious of time, I'll be quiet and turn to others in respect of some of the other matters in your question.
Okay, can we move to Ms McCloy and then Mr Henderson? Briefly, please, if you can.
Thanks. Yeah, I'll try and be brief. It was just to answer some of the specific questions about this setup and ongoing costs of implementation and delivery. As Paul said, we've set out these as best we can in the financial memorandum, and we have had a keen eye on this in designing the delivery vehicle of Redress Scotland, and that's why we have gone for a small independent decision-making body supported by government administrating the scheme, and that way we can keep costs down and there's access to shared resources and shared services. I understand the financial memorandum does indicate some of the different things that we've thought about in terms of the programme costs, including recruitment and staffing, digital and ICT, estate, other services, and obviously communications and engagement, because it'll be very important that we reach the survivors that we need to, so we're inclusive in those that can apply to the scheme. Our estimation, I think, in the financial memorandum is that it could be up to 34 million across the 4 years in terms of implementation and delivery. That wouldn't include money for legal fees or money for non-financial redress. I don't know if that's helpful for just now, but if there's anything else we can follow up on later.
Mr. Henderson?
No, I think that's fine. Grateful to Lisa for details. That 34 million number is the answer to your question, Mr. Green. We should be there faster. A lot of it is dependent on volume. However, the actual setup costs are really pretty marginal. The real costs come in relation to the numbers of people that will need to be appointed through public appointment process to make the decisions, and the scale of the back office activity in Scottish Government. If we are wildly overestimating and it's 2,000 applicants, clearly we need to employ a lot fewer people. If it's 20,000, we will need to employ more, but there are proportionate increases or reductions there accordingly.
Going to move to Mr. Neil to be followed by Ms. Mackay.
Thank you, Convener. As I understand it, the total costs have got 4 elements: £400 million in compensation estimate, 34 million in basic administration of the scheme, plus legal fees, which is indeterminate at this moment, plus non-financial support. So if we add all that up, what percentage of those costs do you anticipate being funded by the offending institution? And what level of commitment have you got at the moment?
Mr. Henderson?
Come in with more detail if time allows. It's too early in the process for us to have numbers. Understandably, the conversations that we're having with organisations are in turn dependent on whether on the shape of the bill. If Parliament passes the bill come March, what the shape of that bill is. Is it as introduced, or have there been changes along the way? And we won't have, the reality is we won't have signatures signed on bits of paper before organisations know the final shape of the bill. What we do have is a number of promising conversations going on from providers, who many of whom we know are keen to find a way to contribute, but it does depend on the work which we're both now embarked on in the parliamentary progress.
So basically, we're being asked to pass a bill with this waiver provision, which is supposed to incentivise these offending organisations, many of which are very rich. They've still not made any ballpark commitment to funding, even in principle, I presume from what you said, Donald, even in principle, haven't made the commitment to partially fund or significantly fund these costs. And yet we're saying to survivors, take the money, but on condition you don't pursue these organisations for civil action. Why should we pass a bill based on a wink and a prayer hope that these institutions will live up to the responsibilities? Because many of them to date have not done so quite blatantly.
I'm not sure if it quite constitutes agreement in principle, but there are, as I mentioned, there are certainly organisations that are very keen to find a way to join the scheme. When it comes to a survivor's application, then we will know, and particularly at the end of that process, it's at the very end of the process that the applicant would be invited to sign a waiver. They will know exactly who has contributed to the scheme in fair and
Donald, once the bill's passed, what leverage have you got over these organisations? Surely before we decide what to recommend to the Parliament, whether to support all the principles in this bill, one of the key principles is this concept of giving people a choice. If you take the money, you waiver your right to civil action. Why should we vote for that when there is no guarantee at stage one, prior to stage one, even in principle, that these organisations are going to live up to the responsibility? This isn't an incentive. This is letting them away with what they've done all those years. Surely we're entitled to have some kind of commitment before we're expected to pass the principles of this bill.
if an organisation fails, it doesn't make fair and meaningful contribution in the first place, or if it fails to make fair and meaningful contribution that it has agreed, then they won't be subject to the waiver and the question doesn't come up. They will have made the decision that they prefer to see cases go through the civil courts with the courts attached.
The fundamental point is, as a legislator, I don't just want to know they've made some kind of contribution. I want to know that they are going to be making proportionate contributions because they are the source of the problem. Their failure to protect these children is the source of the problem. That's why we're here today. And quite frankly, a wing and a prayer doesn't do it.
Well, I think we're here today because, sadly, because of wider societal and regulatory failures. There was not an understanding among regulators, which is why Scottish Government has its own responsibilities. There was not adequate scrutiny, there was not adequate inspection and follow-up. And yes, by and large, it was other people, for instance, than government or our predecessors in government who were...
That's like the criminal. We can understand.
Sorry, Mr Neil, I understand that you want to answer, but I know that Lisa and Paul want to come in. Sorry, Mr Neil. Mr Neil, Paul and Lisa both indicated they want to come in this answer. I'm going to let them answer the question and then move to Mr Gibson, sorry, Ms Mackay, followed by Mr Gibson. I will come back at the end, Mr Neil, if there's more time to examine this. Okay. So can we move?
Thank you. I think it's. I hope it's helpful if I just emphasise that that protection of waiver will only be in place if the organisation is making fair and meaningful contributions to the scheme. As I said, we're working on the principles of that just now. But what I can say is that one of the core elements of that we're proceeding with just now, which hopefully is reassuring, is that we are looking to organisations to pay the equivalent of the individually assessed payments for survivors who come forward to the scheme over and above a starting contribution from government to reflect that wider systemic concern that Donald referred to now. So it will be proportionate, it will relate directly to survivors, and it will relate directly to the decisions taken by Redress Scotland as to what's appropriate for survivors. And if that's not forthcoming, and if that's not delivered in advance, if that delivery does not begin in advance of redress decisions being determined, then that protection, the waiver, does not apply, and survivors can continue to raise legal action in addition to receiving the redress payment. No survivor will be disadvantaged by not receiving a redress payment at any stage.
Oh, thank you. The only thing that I would want to add is, as Paul said, that the waiver only extends to those who have agreed to make fair and meaningful contributions. It's not a blanket prohibition on all who accept redress payments against any action in relation to the abuse that they suffered. Where there is a party to that abuse who hasn't made a contribution, the survivor will still be able to raise a civil action against them, regardless of having received a redress payment. And that's not how all redress schemes operate. Some redress schemes do have a sort of blanket prohibition on civil action should you choose a redress payment rather than court. But the model we've gone for is that survivors would only be unable to raise actions against those making fair and meaningful contributions to the scheme, and we understand the need for transparency around what makes up a fair and meaningful contribution, and I think Donald may have something to add on that.
I think we're going to move to a question for Ms Mackay, but if Donald wants to comment on that in his answer, that would be fine. Ms Mackay to be followed by Mr Gibson.
Thank you, Convener. Yeah, just to follow on from Alec Neil's line of questioning regarding contributions, this is obviously a historical redress scheme, and it strikes me that a lot of the care organisations and charities who would be culpable or involved at that time will no longer exist. Has there been an assessment done of
how many of these organisations are no longer here, and what financial impact that will have on the compensation scheme.
Mr. Beaton, I think you're indicating you want to answer on that one.
Yes, thank you. I would say that process is ongoing. It's not final yet. As I said earlier, we're looking at a really relentlessly complex picture of multiple responsibilities held by different actors and agents in different sectors over different periods of time. Some of the organisations where contributions are being sought continue to provide really vital services for vulnerable people today. Some are reconstituted in a different form. Some are no longer present within Scotland, and as you say, some no longer exist. We will just have to make sure that survivors continue to receive the redress payments to which they are entitled, irrespective of the status of that organisation. We've had discussions with a really broad range of organisations thus far, and we've included within that a number of trusts and other similar bodies which hold legacy responsibility for organisations which no longer exist. But in terms of a conclusion to those discussions and what the ultimate financial impact will be, I think that will depend on survivors who come forward to the scheme and the organisations named in the applications as we move forward. We are looking to be in discussion and to seek contributions from any organisation facing up to a historical legacy in this place, but that's very much an ongoing process.
Thank you. Do you have a sense of how many organisations that would be that no longer exist?
I don't, to be honest. I think one of the things is that we have a number of different databases on this, as you would expect, and there are literally hundreds of names who may have had a role in the care system over by and large the post-war period. We've made contact with all organisations subject to the Scottish Child Abuse Inquiry, for example, and we're now reaching out to others who may have an interest in this, but we can't definitively say so. So. Regrettably, no, I don't know how many organisations don't exist, but we'll continue to look.
Right. Thank you, Convener.
Thank you. Mr. Gibson, to be followed by Dr. Allen.
Yes, thank you very much, Convener. Good morning, panel. I noticed that there could be up to 11,000 people applying for these payments. In Ireland, though, which is a smaller population than Scotland, the Republic of Ireland, there were over 15,000. So I'm wondering, what is the difference between Scotland and Ireland in terms of the pool of people who could apply for these? In other words, how many people were there in care for the time period that we are looking at, and what proportion of those does the panel believe were abused?
Ms. Henderson.
Yeah, thanks very much. Sorry, I didn't realise my mic was on there. I don't know whether one of my colleagues has the detailed figures of the numbers in care in Scotland to hand. If we don't have it to hand, we will write to you, Convener. The number, as Mr. Beaton said, is relatively stable across the year, surprisingly so, but distribution between foster care and residential and others varies significantly. Each country that has established a redress scheme has been dealing with its own circumstances. And the circumstances in Ireland, which right enough has about 4 million population from recollection, as against our 5 or 5.5, were quite different. And although our regulatory procedures did not work as well as we would now wish they had in past decades, in Scotland we by and large did have them, whereas in Ireland there was a different setup in terms of the provision of education, and there was a different setup in terms of the inspection of education. Ireland lost, for instance, a case in the European Court of Human Rights, the O'Keefe case, in 2014, but relating to historical abuse, largely on the basis that they simply didn't have. It's not that they did, that the instruments that the state should have had didn't work as effectively as they could have done. They just didn't have those instruments, whereas by and large in Scotland we did. So that is but an illustration of the fact that each country needs to look at its own circumstances, because those circumstances inevitably vary from one another. We learn, and we have learned a huge amount from colleagues in Ireland, that the historical situation was simply not exactly the same in Scotland, and therefore our answer is different.
Okay, but we don't know what the proportion of people in care in Scotland were subject to abuse. So it seems to be the answer I'm getting, because I'm not getting a specific answer. So I would like that if you can. But when we look at what's been said by other members in terms of organisations whose lack of care contributed to this this problem that we're trying to address, what's happening in terms of foster parents who may have abused people in their care? Are they being expected to make any payments at all through this legislation?
No, they're not. We are children who were in foster care are eligible for applications, but we're not even attempting to have conversations with individual foster carers. For those survivors who want to take civil action, that route is open to them, but we are not including foster carers in any potential contribution to the scheme. We are, of course, talking to COSLA and Three Downs local authorities in relation to the wide variety of responsibilities that local authorities had over these 7 or 8 decades that we're looking at. But one of those responsibilities was in relation to the foster care network.
Is that not a flaw in the legislation? Because you're talking about institutions being responsible, but surely if someone is personally and directly responsible for abusing an individual, they should not be allowed to go off scot-free. That seems to me a kind of a real weakness in the legislation, I would have thought.
There are, of course, any allegations to criminal offences or any criminal case can continue to be brought. Civil cases can continue if the survivor wants to, and can include individual foster carers. We've made a judgment that in terms of diminishing returns, and given that the historical period that we're looking at, that we would spend more finding people and then having a financial conversation with them than we would get in, that there would be no value to it.
Okay, and there tends to be, and on the evidential threshold, there is a real difference in my view between those who are looking for the higher payments, who have to have documentary evidence presented, and those who just accept the minimum £10,000 payment. Effectively, they make an oral declaration for their £10,000 award, but if anyone who suffered serious, much more serious abuse, they have to come up with much more detailed evidence, which can then obviously be looked at. But is there not a huge gulf between the £10,000 award and the 20, 40 and 80 in terms of the proof that individuals are expected to provide, often for fairly modest amounts, given the fact that they could have suffered a lifetime of trauma as a result of what happened to them in care?
Well, the fixed rate, the structure of this particular, the structure as regards a fixed rate payment and then an individually assessed payment comes through work that we've done with survivors through the interaction review group. Again, as part of trying to give survivors choice. In the individually assessed payment application, Redress Scotland will look at everything that the survivor is able to bring. And that will certainly have to include a personal statement, but it can also include health records. It can include any police complaints they've made in the past. It can look at wider environmental information in relation to the children's home they were in and any convictions that have been there. The totality, the wide totality of evidence which we, Redress Scotland, not we, Redress Scotland can find, or which the survivor can bring to bear, all of that will be looked at and assessed. And actually, when we've worked with survivors through the advance payment scheme, which is much, much simpler and has the equivalent of a fixed rate payment. But when we've worked with survivors, even on proving that they were in care, survivors have come to us thinking they didn't have evidence, and we've helped them find it. And we haven't rejected a single case in relation to somebody from sometimes many, many decades ago establishing that they were in care. We've always found a way, and that would be our intent for Redress Scotland as well.
I think Ms McCloy wants to come in on that point as well. Can I just ask for clarification in the answer to Mr Gibson's question about foster care? That would be an informal foster care arrangement, but obviously if somebody was placed in foster care by then a local authority or by social work department, that would be covered by the redress bill. Could I have clarification on that? I'll bring Ms McCloy in.
Yeah, that's right. Just to give you clarification there. Private fostering arrangements wouldn't be included in the bill, but the arrangements you described by a local authority would be covered in the eligibility criteria. No, it was just to add to what Donald has said about evidence requirements. The evidence will be required for both fixed rate and individually assessed payments, but you're absolutely right that there will be more evidence that will be required for the individually assessed payments, given the type of assessment that will be carried out in those cases. And as Donald has mentioned, we want Redress Scotland to be well informed to make decisions, so they will be able to consider the information provided by the survivor. But if the survivor wishes assistance to obtain information, there are powers within the bill to offer that assistance to survivors, and that may include getting information from third parties. There's also the power to commission reports to assist the survivor in the process, whether that's a psychological assessment or a medical report. We do understand that given the historical nature of the abuse that we're talking about, and we also understand that there are difficulties in adequacy of record keeping and difficulties in evidencing abuse of this sort. So we will be taking a flexible approach to make sure that whilst the scheme is robust and credible, it's not setting unduly onerous burdens on survivors to access redress.
Okay, I'm going to move to Dr Allen to be followed by Mr Greer.
Thank you, Convener. We've heard the phrase fair and meaningful quite a few times in this conversation when we're talking about the contribution which might be made by organisations which had responsibility for children in the past. I'm still not much clearer knowing what fair and reasonable might mean. So I wonder if you could explain that, and part of that. You also mentioned some of the explanations that organisations could use in a way not to pay, one of them being that they currently provide services which are useful, and I don't dispute that, but I'm not sure how that gets round liability morally. And the other one, a part of that again, is about bequests, and can you say something more about how we get around the problem of organisations which say, well, we have lots of resources, but they're all subject to restrictions contained in various bequests?
Okay, Mr Beaton.
Microphone has come back. There we go. Yes, absolutely. Thank you. The fair and meaningful discussions, as I said, have been at the core of what we've been taking forward with organisations. I might turn to Barry in respect of some of the law around charitable reform and restricted funds. The essential point there is that we want to make sure that where organisations are looking to play their part and make contributions, that there are no barriers in them doing so. But Barry can speak a little bit about that if time allows. On the point about services and affordability and so on, I would agree. It doesn't bypass liability or responsibility as you describe, and it's not and it's absolutely not diluting the sense of fair that we're looking for here. In respect of meaningful, what we're trying to do is offer choice to survivors, as we've said, something of that collective national endeavour where all have their role to play within this effort to face up to the past. And in doing so, we're looking for people to contribute without formal findings of liability, without a scheme which proceeds on that basis, without requiring people to go through the process of litigation, and in a way which builds as much of that collective as we possibly can. And in terms of FAIR, that's really tightly tied to survivors who come forward to the scheme. It's accepted by government that there's a need to demonstrate commitment and acceptance of that broader responsibility, and others have mentioned the local government complexity within that over the period covered by the scheme. But above and beyond that initial commitment and the initial contribution, we're proceeding on the basis that FAIR is for the organisation to deliver the remainder of the individually assessed payments for survivors as a contribution for the benefit of survivors across the scheme, which is why the waiver is designed in the way it is, rather than being something of a more narrowly considered situation. Again, it's a point which is absolutely ripe for discussion as we go through here. And whilst we write about fair and meaningful in the face of the bill, transparency is key within that space as well. Absolutely, we need to provide reassurance to survivors, the basis on which the contributions are being made, and the certainty that those will be delivered. And also in respect of organisational matters, we do want to encourage them to play their part within this. We do want them to be able to deliver those contributions, rather than shying away from that willingness to participate for other reasons, and hopefully that proves to be the case.
Dr. Allen, did you want to, I think Mr. McCaffrey was going to come in that one too.
Yes, thanks very much. Just to supplement what Paul said, on the issue that Dr. Allen raised about bequests, we've had engagement with the charities sector and the regulator, and I suppose the issues we've been trying to address operate at two levels. That, in terms of general charities law, that there are potential barriers to contributions if it's contrary to the constitution of the organisation or not meeting the charities test. So we've tried to address that in section 14 by removing any doubt that contributions from charitable bodies would not in any way contravene charities law. In relation to the issue of bequests, it's a slightly trickier issue, and we've taken an enabling power in section 15 to explore that further. A lot of funds may have been, contributions to charities may have been tied up in what are called restricted funds, so tied up for a specific purpose. So we're continuing to engage with the charity sector and the charities regulator on that, but our idea would be to bring forward regulations that, in a similar way to section 14, that trying to remove barriers that would otherwise be in the way of funding from contributions to the fund from charitable bequests tied up in restricted funds.
Dr. Allen, do you wish to come back in?
Thank you. On the other side of the equation, but again related to all these things, talking about the payments made out, keep me right, but my understanding is that the £10,000 option involves, if you like, a simpler process and the need to explain less in a way than the higher sums. How do we avoid a situation where the people who find it most difficult to talk about what's happened to them feel that their only option, or that their simplest option, is to go for the £10,000 option, regardless of the severity of the offences against them? So how do we balance that? I appreciate it's a difficult balancing act to do. How do we avoid situations where the people who find it most difficult to talk about this stuff go for the simplest option?
Mr. Henderson and Ms. McCloy.
Very important point. We have advisors in the government on advance payment that sometimes first person they've told about the abuse is one of my colleagues who supports the work. There's no easy answer to that, but the provision of support is a part of the answer to it. We've also been careful to design the scheme so that an application, and indeed a settled application for a fixed rate payment, doesn't preclude the survivor coming back later in the lifetime of the scheme to open an individually assessed application if that's what they decide to do. That still doesn't, I'm afraid, because of the delicacy and sensitivity of it and the difficulties that survivors have faced, it still doesn't wholly answer the question, but we're always trying to find ways to give choice and maintain that choice for as long as we can in the process.
Ms McCloy?
Thank you, Convener. No, I was just going to make the same points as Donald, that we are making sure that we have provision to support applicants through the process. We will learn from our experience in advance payments, and I think the point that Donald makes is important about those who receive a fixed payment will be able to then later apply for an individually assessed payment. And we know that sometimes survivors have stage disclosure, or we know that sometimes they want to test services to see how they will meet their needs and how sensitive they can be to them. So we hope that will provide more choice.
Okay, thank you. I'm going to move to Mr. Greer.
Thank you, Convener. I should say at the outset that construction work has just started immediately outside my office, so apologies if the microphone picks up the jackhammer that's just started. I'd like to ask a few questions around the next of kin payments. So for cohabitants to be eligible ahead of a spouse through marriage or civil partnership, they need to have lived with the deceased survivor for at least 6 months. And that seems like a proportionate way of indicating that they were the deceased survivor's partner at the point that they passed. Can I just ask for a bit of clarification? Is there a similar provision for the length of time that the cohabitant needs to have lived with the survivor for them to be eligible ahead of the survivor's children?
I can respond.
Mr. McCaffrey, yes, please.
Yep. Well, yes, on cohabitants, we've taken a sort of proportionate approach. We've actually looked at other legislative frameworks. There's similar type of provision in the Burial and Cremation Scotland Act as to who can take arrangements on the death of a person. On the more general point, in every case, the next of kin, the category has to be spouse, civil partner or cohabitant. And they rank ahead of surviving children on the basis that it was felt that in the first instance that the actual partner of the deceased survivor should have first call on whether to make a next of kin application, and it's only if there's no one around in that class then the surviving children would come into play.
Sorry, just to clarify that, Mr. McCaffrey. Does there need to be any length of time that the cohabitant has lived with the survivor for them to be ahead of the children? So the scenario I'm thinking of is, they need to have lived with the survivor for at least 6 months to be ahead of that survivor's partner, that survivor's spouse. If someone has lived with a survivor for a matter of weeks before they passed away, does that make them eligible ahead of that survivor's children? Do they become a cohabitant above the child, or without any residency length of time requirement in the same way that they have to come ahead of a spouse?
I'll be just double checking, but I think the answer isn't that that they don't. Let me just double check. I'll come back. I'll check that and come back to you.
Thank you.
Yeah.
Sorry. Mr. Greer?
Yes, thanks. I've just got one more, and I think it's a relatively brief technical question. So the next of kin payment, they're eligible for the fixed payment of £10,000. Is it simply the case that they would need to present in exactly the same way that the survivor would have, to provide evidence that their deceased partner had been in whatever the setting was, provide evidence of when they were there, and to simply state that they were abused, they would not be required to provide any more information than the survivor themselves would have had to were they still alive.
Ms McCloy?
Thanks. Yeah, we recognise that next of kin can be a challenging area in terms of the evidence that next of kin will have access to. But yeah, I think your general understanding of the bill is correct. They won't have to be able to produce anything over and above what a survivor would have to. We do have to look carefully at the requirements for evidence in terms of next of kin. At the moment, we're expecting that we will have to have more than simply hearsay evidence from the next of kin applicant that the underlying survivor had experienced abuse. So it may be that they will need to access a previous statement or a previous account from the survivor. I think what's important to note here is that in terms of the next of kin provision, the entitlement relates to the underlying survivor and their inability to access the redress scheme.
Thank you, Ms McCloy. We've very quickly almost run out of time. Can I just ask a final couple of points just before we finish this session? The first one is in relation to the definition of abuse, and I know that it's mentioned that there's about corporal punishment at that time, but we would now consider that to have been abuse by today's standards. So how can we have the confidence of survivors that abuse will be recognised and dealt with, and also can I have a little bit of an understanding about what non-financial redress will look like? And I think Mr Henderson's indicated he wants to.
I'll come in on those questions. Thanks, Convener. On corporal punishment and definition of abuse, our aim is not to criminalise behaviour which was perfectly legal and accepted at the time, bearing in mind that we are going back to activities certainly post-Second World War and even in some cases before the Second World War. And so our aim is not to penalise, as it were, what was perfectly normal in Scottish schooling, including my own schooling, where one could receive the belt, for instance. So our aim is that if it was simply the normal experience that school children had in Scotland, that doesn't in of itself constitute abuse. It's, however, possible that corporal punishment, if taken in extreme patterns, could constitute abuse, and we are looking hard at the various regulations that were in place as regards residential care as to what was acceptable, because actually the rules and regulations were often different in residential care than in normal day schooling. But the principal point is we are aiming to address behaviour that was actually illegal and unacceptable at the time, but which was ignored for too long, and that becomes the ignoring for too long becomes a part of the injury. That's what we're trying to address.
And in terms of non-financial redress, is Mr. Keating going to come in on that one, or Mr. Henderson?
If I can start, then others may be able to come in. It links very much to the support elements to this, but we know from survivors that just somebody signing a cheque, regardless of how efficiently that is done, is not the answer they are looking for. They are looking for acknowledgement, they are looking for apology, and again, looking at the experience that we have from the advance payment scheme, I or one of my senior colleagues has written out a personal letter of apology to each survivor, because we know that makes a difference. We have heard stories coming back of survivors reading that letter each night before they go to bed because it helps them sleep, because it's the first time that somebody in authority has listened to them and has acknowledged that what went on should not have gone on, and that that public services need to respond to that. So acknowledgement and apology is a vital part alongside the financial redress, and links quite closely to the support. Our aim would be, although a great deal of this would be for Redress Scotland, is that in understanding what each survivor wants, that the process should do as much as it can deliver that, because the package that will help each survivor may be different, and we need to listen to their voices in it.
Okay, I'm afraid we have now run out of time, as we do have another panel this morning. Can I thank everyone for their attendance this morning? I know that Mr McCaffrey wants to come back on an answer, certainly, and we thank you all for your attendance this morning. Apologies to Mr Gray, Mr Green and Mr Neal, all of whom wanted to continue a line of questioning. I'm sure the committee will be following that up by later, and we look forward to receiving your response to that. We will now suspend for 5 minutes to allow the panels to change over. Thank you. Welcome back to our second evidence session on the Redress for Survivors Historical Child Abuse and Care Scotland Bill. And I welcome to committee Dr. Maeve O'Rourke, Lecturer in Human Rights Law and Programme Director, BCL Law and Human Rights, the National University of Ireland, Galway. We're going to move straight to questions to Dr. O'Rourke, and can I open by asking her what were the major lessons learned from the redress system in Ireland, and what might they do differently this time?
Sure. Okay. Thank you so much for having me. It's a real privilege and no small responsibility to be here. I really do take that extremely seriously, and I think it's worth stating for the record that I really do consider the survivors of these abuses to be the absolute experts, and I offer what I can from my limited experience, but that is over a decade of working alongside being a barrister in child law, doing a PhD on the rights of older people, to freedom from torture and ill treatment and to redress for those harms. And now as a lecturer, I've worked voluntarily between 10 and 20 hours a week for the last 10 years on issues of so-called historical abuse in Ireland. So I think what we can learn, I'll speak to the two schemes that were mentioned in the briefing papers, which one I have a great degree of knowledge of, another less so, but still a considerable amount. The first that I'll speak to is the Residential Institutions Redress Board, which was established in 2002. After 2 years after the Commission to Inquire into Child Abuse began its proceedings. And these two measures, the inquiry and then the redress board, were prompted by an apology by former Taoiseach Bertie Ahern in 1999 to survivors of industrial and reformatory schools. And we've heard a little bit from the officials in the previous session about Ireland's setup, but essentially they were state-funded, statutorily based institutions, but really left to their own devices in terms of how they ran. And the abuse ultimately in the report of the Commission to Inquire into Child Abuse in 2009 was found to have been endemic. So that scheme, set up in 2002 under the Residential Institutions Redress Act, is the one that I have less knowledge of, but in my work, in particular with Magdalen Laundry survivors, lots of them also are survivors of industrial schools because there was transfer of teenagers, if they were girls, into Magdalen Laundries, and that's where most of my knowledge comes from. I think a very positive aspect of the RIRB, as it's known, the Residential Institutions Redress Board, at its outset was the promise to provide commensurate compensation, commensurate to legal proceedings, and as you'll have read, that was going to be up to, and in some cases beyond, €300,000. As it transpired, the average award, as again is in the briefing notes, was in the region of €62,000. So what I think promised at the outset to be commensurate really didn't end up being. And I will speak to the procedures of the redress board in a moment, because they are considered and stated by some survivors to have been deeply traumatizing. It's very difficult to understand actually how exactly the redress board affected most survivors, because there is what is colloquially known as the gagging clause in section 28 subsection 6 of the 2002 Act that underpinned the redress board. That prohibits everybody, including survivors, from discussing an application to or an award from the redress board in any way that could possibly lead to the identification of an individual or an institution involved in what they complained about. And that has absolutely operated as a massive chilling factor, so that the only voices we really hear are very well supported by, for example, our national broadcaster, RTE, when they report, but the reporting is minimal. It's worth noting that this section 28.6 gagging order has never been acted upon legally by the state. So it is a massive chilling, has a massive chilling effect. It doesn't seem to actually be understood by the state to be effective, possibly not constitutional. But unfortunately, that does hamper our understanding of the impact of the procedures. I'm trying to look. I did make notes about positives and negatives. I'm afraid that with the redress board, I do have to move on to negatives pretty quickly. So the procedures, and then we can compare them to what I see in the Scottish Bill. It was an ex gratia scheme. It stated explicitly in the underpinning legislation that any award could not be construed as finding a fault against any institution or individual, but nonetheless, under the legislation and the guidelines, every person or institution that a survivor named in their application was entitled to a full right of reply. They were entitled to receive all of the survivor's documentation, and they were entitled then to respond to the board with any evidence in writing concerning the application, any evidence such as the relevant person considers appropriate. They were entitled to request the opportunity to cross-examine the survivor, either themselves or through a legal representative, for one of three purposes. One, correcting any mistake of fact or misstatement relating to or affecting the relevant person made in the application. Two, defending the relevant person in relation to any allegation or defamatory or untrue statement made. Or three, protecting and vindicating the personal and other rights of the relevant person, and the relevant person being a person or a representative of an individual named. And the only reference to rights in the entire Act was in relation to the rights of the alleged wrongdoers. And as I say, it was nonetheless an ex gratia scheme, and the legislation also said that none of the documents provided to the redress board could ever be used in future criminal or civil proceedings. We also have extremely strong defamation law in Ireland, so in my academic view, these procedures were wholly unnecessary, and they did, as we can tell from the survivors who have spoken out and who have taken the risk of breaking that gagging order, had a massively traumatising impact, and it is very welcome to see that there doesn't seem to be anything comparable in the Scottish Bill. Another downside of the 2002 Redress Board Act was that the awards were accompanied, like I say, by the gagging order, which even though it didn't strictly have this effect, many survivors felt it meant they couldn't even go to the police. There have not been prosecutions to speak of in relation to the industrial and reformatory schools. And access to the records relating to the industrial and reformatory schools is massively problematic. In 2019, the Department of Education brought forward the Retention of Records Bill, which seeks to seal for at least the next 75 years, seal entirely, even from survivors themselves, every single document gathered and held by both the Commission to Inquire into Child Abuse and the Residential Institutions Redress Board. I do accept that the arguments in relation to, for example, some publication to the public of records are stronger in relation to state and other administrative documents from the Commission to Inquire into Child Abuse, but in terms of the Redress Board's records, survivors themselves, of course, have an entitlement under the GDPR to their own personal data, and that doesn't seem to be recognised in that bill. The interpretation of the GDPR is also an issue that I would like to discuss. I don't know to what extent it's a problem, if at all, in Scotland, but certainly there's no understanding, in my view, in Ireland, of the concept of mixed personal data, which is that a survivor has an equal right of access to data that belongs to somebody else if it's also the survivor's data, i.e. information about what somebody did to me. For example, you and I have a right to know who our doctor is and what they've done in relation to us in our medical records. That is our data as much as it is theirs, under the European Court of Justice case of NOAC and the Data Protection Commission in Ireland. So that, unfortunately, is definitely not being properly understood in Ireland. Following the establishment of the Redress Board, there was the provision of non-financial support as well in relation to industrial and reformatory schools. And this partly came out of the controversy over the very small amount of compensation or of contribution that the religious orders had given to the Redress Board, and they were called upon to give more. And this went into a separate statutory fund that then began to administer other payments to survivors and to an extent second generation survivors for education. This then turned into a fund called Cara Nua, which is Irish for new friend. And unfortunately that fund is now being wound up. So there is from survivors a sense that it's not understood that their needs continue forever, for as long as they live. So the Cara Nua fund provides things like help with house renovations, educational support. I'd like to talk a little bit in due course, if we've time, about the very real need for survivors of child institutional abuse not to be re-institutionalised. And so home care is a massive issue, as are home renovations. And so this was a fund that provided some help for that kind of thing, and it's being wound up now. And the last thing on the industrial and reformatory schools that I would like to mention is that there was a pre-consultation report. It was a consultation with 100 industrial and reformatory school survivors in July 2019 to find out what should be the method and issues for a fuller consultation with industrial and reformatory school survivors, funded by our Department of Education, by the authors Barbara Walsh and Catherine O'Connell, and I'm very happy to send any documents after this meeting. And that did speak to 100 survivors about what their ongoing needs are. So I'm very happy to come back to that. The Magdalene, I'll talk about if you like.
Okay, thank you very much, Dr. O'Rourke. We do have 10 members in the committee, all who want to come in, so if we could try and be succinct in both questions and answers, that would be very helpful. Can I bring in Mr. Johnson first? Be followed by Victor.
Thank you, Convener. I was quite interested by what you were saying in terms of the sort of the controversial nature of the procedures for making the determination, and you'll have heard in the previous panel, I have some concerns that that's essentially to be defined in guidance with the bill that we're looking at here. I was just wondering what your reflection was in terms of the importance of actually putting some of these safeguards and indeed high-level principles actually on the face of the bill, in particular, given your experience as a barrister. And actually, moreover, clearly the contrast here is this is a panel making determinations in private and then reporting them, whereas in Ireland you had public hearings. And I'm just wondering kind of what your thought was in terms of the compare and contrast on that particular point.
Absolutely. So the redress board was private, even though there was the cross-examination, but it was as if it was a court, but still private. But I think that's a really important question. So I think fair procedures still have to apply, even if you do not operate it as if in any way that it's a court. So the second scheme that we've had more recently in Ireland really did, I mean, to give credit to the ministers who established it, they really did want to avoid the traumatising effect of the previous industrial schools redress scheme. So this was the Magdalene scheme established in 2013. The problem with this one was, first of all, there were no lawyers to help the women through the scheme. Second of all, the officials who administered it there was no published guidance on what the criteria were, what the decision-making process was, and they didn't seem to understand that it was an administrative scheme affecting rights, therefore the ordinary fair procedures still applied, this obligation still applied, and ultimately I was involved in bringing together judicial reviews of what was found by the High Court, but also in a larger investigation by the Ombudsman to be maladministration and denial of fair procedures, because the women were dealing with something totally opaque all on their own. It was said that all they needed to show about their time in the Magdalene laundries was their duration of detention. But, and this is something that we see in the Scottish bill, unfortunately there was an absolute requirement for records. Now, it was known actually as a result of the inquiries into the Magdalene laundries that there were not records. The nuns did not have records for all of the women. In fact, for more than half of the women, it seemed even back in 2013 there were not sufficient records. But because the women had no lawyers, they were not enabled to swear a witness statement or an affidavit, and there was no one to receive their evidence. And so they were caught in phone calls constantly on their own without even independent advocates to help them. And I would say that I do think independent advocates, as well as lawyers, because there are some things that, lawyers may well be too expensive for and not well equipped for, but I do think independent advocacy is extremely important in these schemes. But they were just caught in a horrible situation where they were told they had to get records. They were given no way of proving their own duration of stay. The Ombudsman ultimately found that their own testimony and that of relatives and friends was not given any evidentiary value by the officials in the scheme. And so I would say there's a real need, even when you're doing something very non-adversarial, to nonetheless be extremely strict with yourselves about ensuring fair procedures, because it benefits everybody in the end of the day. And I'm not sure that it was a massive problem to have a matrix in the redress board, the redress board for industrial schools. I noted in the briefings on the Scottish bill that there is a suggestion that the matrix might have been a problem. I think the procedures where there was the full right of reply and to be cross-examined by the church was a massive problem. But having, boxes that set out what kind of points essentially apply to vary, how we decide that you've met these criteria, I'm not sure is a massive problem, because there is a need for transparency.
Sorry, Daniel, were you wanting to come back in? Very briefly, please. We're having a lot of sound interference, just to let Dr. O'Rourke know if she's aware of it or not, because there is a lot. I think we've switched as many microphones off as possible. So, but we'll bring Daniel in very briefly.
I just wonder how important the point of fault is. I mean, I note in section 34, subsection 3 in the bill that we're considering, it states that when determining an application, the panel must not consider or make determination on any issue of fault or negligence arising from any matter to which the application relates. How important do you think it is actually that the process does actually deal with fault, or do you think it's simply about acknowledging the issue and kind of putting that on the record for the survivors?
My feeling is that there should not be a waiver, so I suppose it's connected with that, because I think that this should be an interim measure to provide the beginnings of rehabilitation to people, and accountability is a different issue, so maybe we can speak about that afterwards. So if you accept, I suppose, that you're still allowing people seek legal accountability, then there's no problem, I would have thought, with having something that is ex gratia in the meantime. I think that bringing fault obviously brings in causation, and that was a massive issue in the redress board for industrial schools and reformatory schools, because people were then, having to be examined by psychiatrists. The survivors felt like it was themselves who were on trial rather than the people who were wrongdoers. And I see that there's a massive relaxation in the proposed bill of the notions that applied in our residential institutions redress board, that you had to show that the injury directly related to the abuse, and people were cross-examined on things like, was it not because you were abused so badly before you went into care that you are now the way you are? And that is just not an acceptable situation to put people in. But the waiver, in my view, is an issue, and I would say that there are other ways to do it.
Thank you.
I'm going to move to Beatrice Wishart, to be followed by Jamie Green.
Thank you, Convener, and hello, Dr. O'Rourke. Your evidence thus far has been very informative and helpful, but I just wondered, my only question is, based on your experience of the Irish redress scheme, do you see anything in the bill as proposed, anything specific that is missing that you think that should be included?
Okay, thank you for your question. My first point that I'd noted was definitely that even though we have a non-adversarial procedure proposed, there's a real need to make sure there's still fair procedures, and that people know what documentation they're supposed to be providing, who's providing it, if someone else is providing it, that the survivors get to see it. And this notion of, I understood in the last session, one of the officials mentioned that next of kin couldn't only rely on hearsay, i.e. so even their own sworn statement of what they know their spouse to have experienced in the however many decades they lived together. I think there is a need to really think through what is survivor focused, and bearing in mind what we know as well about the abuses that have happened. I think there are some really good things about this bill that we haven't seen in Ireland necessarily. No sealing of the information, no gagging of survivors, all very positive. Definitely very positive that on appeal an initial decision cannot be reduced. There was a real issue with the redress board in Ireland where survivors say that the lawyers would go into a room without them. They would discuss with the board and they would come out with an offer, and they would say to the survivor, if you don't take this, you may well not get as much if you go in and, you know, go through the whole process of being challenged, etc. So that's definitely good, and it's good to provide legal assistance in the course of making your application, not just at the end in relation to a waiver, which unfortunately was the case in the Magdalen scheme, the more recent one in Ireland. No lawyers involved because the government said they wanted a non-adversarial approach, but of course lawyers still involved at the end to help you sign away all of your rights against the state. So issues though that I do see with this bill, the time limit of 5 years I think is a problem, because the same applied, it was less than 5 years, I think, in the redress board, and I have come across many women in particular who did not actually realise that this procedure applied to the kind of abuse that they had suffered. Then there are people, particularly in the diaspora, who just do not find out about it. There are people who can't come forward, and one of the very positive things about the Magdalen redress scheme in Ireland is that there is no time limit, and that was an explicit recommendation of Mr. Justice John Quirk, who recommended the Magdalen scheme. Another concerning thing, just as a human rights lawyer, is the exclusion of corporal punishment that may have been allowed under domestic law. Of course, being allowed under domestic law does not necessarily mean that it was compliant with the European Convention on Human Rights or other international human rights law instruments. And also I do wonder whether, to the extent that corporal punishment was strictly allowed under legislation, how that relates to the particular circumstances that somebody who is a child in care is in, and whether there should not be an approach to understanding corporal punishment within the context of their broader abuse. And then the waiver. This is my last point that I've made on issues with the bill, so I really appreciate your patience, but I've got 6 points about it, and I would really recommend serious consideration of this, because I think that it would be possible to legislate so that in any future court action, any damages could be reduced by what someone has already received in this scheme. And of course, this scheme is doing that in relation to previous awards from other places that survivors may have received awards. So I know I've seen two main arguments for the waiver in the briefing. One, of course, which makes sense, is that it's seen as a way of coaxing the private institutions to contribute. But I've also seen another, and that is that it would provide a swifter, non-adversarial, more trauma-informed response to historical child abuse, and I do think this confuses the waiver with the scheme. And I don't see any benefit other than to the taxpayer of the waiver. And of course, that is an interest that needs to be considered, but it does have to be weighed up against the harm that a waiver can cause, and in my view does cause, not only to the survivors individually, but actually to society, because accountability is about ensuring a restructuring for future child protection, as much as it is about an accounting to the individual. So the first point I would say about the waiver is that the abuses involved here are torture and other forms of cruel, inhuman and degrading treatment, which has already been recognised by the Scottish Human Rights Commission. And that the right to be free from torture and ill treatment, as is well known, is absolute. And that does include the right to access justice. as a survivor of torture and ill treatment. The second point is that I'm actually a lawyer on a case that has recently received an admissibility decision from the UN Committee Against Torture on the 20th of January of this year, and I'm happy to forward the judgment. It is available online, although not yet on the committee's website, but it's on the website of HOBA solicitors who are involved in the case. And this is Elizabeth Coppin and Ireland, and Elizabeth Coppin signed up to both the Residential Institutions Redress Board and the Magdalen Scheme and signed waivers, signing away her rights against the state and, in the case of the Redress Board, religious. Now, for reasons that relate to Ireland and our particular procedures and secrecy of evidence, the state still says in relation to the Magdalen Laundries that there is no evidence of systematic abuse of a criminal nature or under the Convention Against Torture occurred in Magdalen Laundries. So she is claiming that the state has failed to properly investigate and failed to provide her with full redress, which includes satisfaction, guarantees of non-recurrence. And the UN Committee Against Torture had to issue an admissibility decision on this because the Irish government said she signed waivers. She cannot take legal action against us. And the UN Committee Against Torture, referring to its own general comment on Article 14 of the UN Convention Against Torture, found in Elizabeth Coppin's favour in January, saying that the waivers do not prevent her coming to the UN Committee Against Torture because the rights under the Convention remain, to accountability remain. You cannot sign away your rights not to be subjected to torture or ill treatment, and just as you can't do that, you can't sign away your rights to accountability. And the general comment number 3 mentions that judicial remedies must always remain in place. I think that what the waiver says is as important as what it does. We've already heard evidence that there are many barriers to litigation and many people will not take that arduous route. But ultimately, it does put survivors in a position to have to choose between accountability and money. And ultimately, I think from our Irish experience, it does say to the public about survivors that they chose money and that was what they were concerned about. And most survivors cannot afford not to take the money available from the scheme, at least as an initial way of achieving some kind of rehabilitation. So I do think that is something that has to be considered. And then we have to consider that court cases are not just about money, and they're not primarily about money for many survivors of abuse. They are actually about having legal findings about what abuse means, who's responsible, and in that way they have an impact on the whole of society. So yeah, I mean, I think I've said enough there. I'm happy to go into more details, but I do feel very strongly that Scotland could take a different approach to this waiver issue and really be leading and world leading in relation to this, because what we are dealing with is torture and other forms of ill treatment.
Thank you very much. We move to Mr. Green to be followed by Ms. Mackay.
Thank you, Convener, and good morning, or good afternoon as it is now. I do appreciate those fulsome answers. These are very complex matters, but I think given the interest of time, we've only got, I think, 10 minutes left and still a number of members with questions. So I'd be happy if you responded to mine in writing to the committee. And I guess that's a simple one, and that's if this bill, as it's currently drafted and presented to us as MSPs in the Scottish Parliament, was presented to TDs in the Dáil, and you were reading it and reviewing it and advising those members of Parliament on anything that jumped out at you as being of concern, what would be the main thing about the bill as it's currently drafted in Scotland would jump out at you as something that we should be looking at as those who will inevitably be amending it and scrutinising it? And I think you said you had around 6 points of interest that jumped out at you on the Scottish bill. I wondered if you would put those in writing to the committee so we can review your independent expertise. I found what you've said so far extremely helpful and useful. Thank you.
Yeah, I'd be delighted to. Yeah, I'll do that in writing. Thanks very much.
Thank you. Can we move to Ms. Mackay to be followed by Mr. Gibson?
Thank you, Convener. Yes, I agree with Jamie. It's really been so useful so far. Can I ask you about charities? It says in the policy memorandum that some charities may have a constitution that doesn't allow them to make redress contributions. They don't have the power to do that. And a lot of their funds are tied up in restricted ways, like donations that have been given for a particular purpose. And there's a fear that this will stop people donating to charities, etc., if they know that funds are going to be used for this. The policy memorandum says that allowing restricted funds would be a proportional intervention, but that power isn't included in the bill. Do you foresee any problems with that? Is that something that should be tightened up?
Well, I don't have expertise in charities law, so I mean, I can see that it would make it easier for the private institutions to make contributions, and I can't see a massive problem with that. I think that the Parliament's powers generally in areas such as this of very sensitive social policy and also extremely strong public interest factors are very broad. But I couldn't say, because I don't know charity law and certainly not Scottish charity law.
That's okay, that's fine. Thank you. Thanks, Convener.
Thank you. Can we move to Mr Gibson to be followed by Dr Allen?
Yes, thanks very much. I was quite fascinated by the conversation about the Magdalen laundries. We actually had them in Scotland, and the last closed in 1958. So I would hope that if there are any, albeit elderly, survivors from that time, they would be included in our legislation, and indeed those from the Glasgow Lock Hospital, which was an institution for women with venereal disease, was closed in 1950. I'm just wondering, with regard to Ireland, you talked about the diaspora. Has there been any attempt to reach out to the diaspora, and is that something you feel that is important that we do from a Scottish context?
Yes, I absolutely think it's extremely important, and it's something that my colleagues in the Justice for Magdalene's research group and I constantly brought to the attention of ministers in relation to the Magdalene scheme. And they did send circulars, and I think they've resent over time additional circulars to every consulate and embassy. And we also recommended advertising in magazines such as Ireland's Own or online places where we know that the Irish diaspora are easily reached. And I don't know, I have to say, whether the government reached out to support, like immigrant support groups beyond the UK. I know that they did reach out to UK-based organisations, but we certainly found that, survivors live all around the world, and so my colleagues and I made great efforts to send out notices beyond the UK, and I think it's absolutely vital, and it does connect again to the time limit. I don't think that a time limit is justifiable as when you weigh up the importance of this to survivors.
Yeah, I think that's a really important issue, the time limit. What kind of response did you get with regard to your work to bring in, if you like, people from the diaspora who'd suffered in Ireland when they were younger?
Well, I organised with colleagues in the summer of 2018 a gathering of over 200 Magdalene survivors, because one of the aspects of the Magdalene scheme that had not been implemented was the women had told Mr Justice Tom Quirke they wanted to meet, and they also wanted to be consulted and to oversee memorialisation. And you see with the Magdalene laundries, and I don't know to what extent this applies in Scotland, but the women's names were changed when they were in there, and if they escaped, it was without warning, and they often never met anybody again. So bringing them together was hugely important for them. And there were women from Australia, Canada, many countries in Europe, and I think for them it was absolutely crucial for to meet and to be connected with survivors, other survivors that of course they would have no contact with in their individual circumstances halfway across the world. So
sorry, and I was going to say, and sorry to interrupt you, but I was going to say, and a lot of them would have probably felt a sense of betrayal of the country they grew up in, and this might have been a way of Ireland itself providing a bit of restoration to that and saying that the country hasn't forgotten about you, and we do feel your pain, albeit belatedly.
Yeah, extremely meaningful. And with Ireland, we often have these big initiatives for our diaspora, and there was a year of welcoming people back to Ireland, and we certainly would have heard from a lot of survivors around that time that the fact that they were excluded from that as well really didn't sit well. I think it's a mixed bag in terms of the effects of having left Ireland. For some women, we've certainly found that it has enabled them to live in a different way than if they're still in a place where, to be quite honest, with the effects of PTSD, people often feel that they could be kind of picked up off the street at any time, or they just feel a great sense of still being in the centre of the abuse that they suffered, I think often.
Thank you. I just ask one more question, Convener, and it's on a slightly different topic. Well, it is a different topic. It's we're talking about organisations who preside over this wrongdoing and the fact that they need to make a contribution, understandably, to this. Has there been, in Ireland's experience, given that nearly €1 billion was paid out, obviously, and some of that would have come from these organisations, was there a kind of limitation put on such that if an organisation was perhaps going to go bankrupt, for example, because of the amount of money that it was supposed to pay, would the Irish government step in or something like that? What kind of because I mean, we've got a lot of organisations, charities, who, if they have to pay significant contributions, may cease to exist. And of course, the wrongdoing was long ago, and they may have gotten their act together since then. So, was there any kind of action taken in Ireland to ensure they paid, but not to kill the goose that laid the golden egg, so to speak?
Well, actually, this is definitely, I think, something worth speaking to possibly your parliamentary colleagues in Ireland, because it's a huge controversy and issue, and that is that the Department of Education, before the scheme was established, the Minister for Education gave an indemnity to the group of religious that came all together, and they promised to contribute, and it was a fight to get them to actually contribute, and my understanding is that they never fully contributed everything that they promised, but I don't have the figures for you, but the indemnity was for 128 million. And then the scheme progressed, and it ultimately cost almost 1.5 billion. So there was no way of going back. They had already been indemnified, and so it's definitely, I think, something worth looking into in Ireland, because I think the general public would feel that the institutions got away almost scot-free. And when it comes to them continuing to operate in society today, it's another reason why access to the courts is important, because they continue to operate in this space, and legal accountability and what that brings in terms of establishing legal standards, lines of responsibility, things that happened. It is still important, bearing in mind that they do still often exercise control and are providing services in this space.
Okay, thank you, Dr. Rourke. Much appreciated.
Thank you. Dr. Allen?
Thank you very much, Convener, and thank you, Dr. O'Rourke. We talked in our earlier session today a lot about financial redress, but we're keen to get your views on non-financial redress. Apologies. What can Scotland learn from the Irish experience? How should apologies be made? How should we ensure they're not half-hearted? How should we ensure that they meet survivors' needs? And was it the experience in Ireland that any institution actually refused to apologise in any instance? For an individual, I mean.
Well, there haven't been proper apologies from the four religious orders that ran Magdalen Laundries, and they never contributed to the Magdalen scheme. And so the waiver that applies only applies to the state. And the reasons, part of the reasons I think they didn't contribute is because it's not easy at all to sue them. And so they didn't necessarily feel any particular need to safeguard themselves from being sued. We have a very strict statute of limitations, unlike your changes. The costs regime allows the religious, and they do always pursue for costs if someone sues and loses, or from day one saying that they will. And of course, the evidence of what happened in the Magdalen Laundries, and it is different to an extent in Scotland, the way that the inquiry has gone in Scotland, not wholly in private, but in Ireland, all of the evidence gathered by the state on the Magdalen Laundries is being held secret, unfortunately, in the Department of the Taoiseach, where it's being held for safekeeping and not for the purposes of the Freedom of Information Act. So there's no way of people getting into court, so they didn't join the scheme. But interestingly, again, to do with people feeling whether an apology means something or not. So because the state has safeguarded itself from being sued, and I haven't found a single Magdalen Laundry survivor who was able to not go into that scheme because of her current situation of living, and because there has been no court action, despite the political apology in 2013, the officials still maintain that there is no evidence of legal wrongdoing. And so over the past 7 years, the scheme on the Magdalen Laundries has progressed, and there were judicial review challenges to a lack of fair procedures, and the Ombudsman got involved in trying to ensure that the scheme was administered, as he put it, in the spirit of the apology that was given, and he mentioned at one point forced labour. And the Department of Justice responded to say, with some very limited exceptions, there has never been any statutory basis for committing a person to a Magdalen institution, or any lawful basis for keeping a person there against their will. So they're relying on something that would be very in itself evidence of arbitrary detention, but no court has ever been able to find that. They say there's been no court ruling that the state has any liability for women who entered such institutions, nor have we ever seen any legal advice or factual evidence that would give rise to the belief that the state has any legal liability. We are also not aware of any successful legal action taken against the religious order concerned. And that was the department's response to the Ombudsman, who said that in his 10 years of being an Ombudsman in Ireland and elsewhere, he'd never come across such a refusal to cooperate with his recommendations. So we can see that the political apology is at risk, major risk, of becoming hollow if there isn't proper accountability to go along with the financial payments. And people have said and used the words crocodile tears, and that just does no justice, of course, to the intention back in 2013. But one of the big things that never transpired in the Magdalen scheme was the proper healthcare, and that is something that, you know, does elicit from some of the women words like crocodile tears when they start to need home care and they're told, oh, the card that you were given is nothing more than an ordinary medical card, when actually it was supposed to be something vastly different. But they had signed away all their rights against the state. They'd got their money. The healthcare was something to come down the road, and it never materialised. So there are issues, even though there can be great intention in an apology, it absolutely needs to be followed through. I can briefly mention the ongoing needs that in the consultation of 100 survivors of industrial schools and reformatory schools last year, they said were required separate to financial payments, if that would be helpful.
Thank you very much. One final question, Dr. O'Rourke, before you go, on the issue of the issuing of an apology. The scheme that's suggested in Scotland is for those who experienced abuse up to the date of the apology. Did a similar restriction exist in either of the Irish schemes? And just to hear your general comments on that.
Yes, that's a good question. Well, our schemes were for institutions that had closed by the time that the apologies happened, so that didn't apply. Yeah, and I'm so sorry. I actually, if there's time, or if you'd like me to, I was just checking if you had time for me to mention the key non-financial forms of redress, but it's up to you whether there's time. Otherwise, I can forward them.
if you've got time, I'm sure we could give a few more minutes. So if you can cover it in that time, that would be great.
Yeah, okay, great. Well, these are the industrial and reformatory school survivors now, which is 2020, so 20 years on from the state apology, and the redress scheme has come and gone, and the additional Cara Nua has come and gone. And what they are saying about what they need is enhanced medical and healthcare, in particular home care. So that I can't stress enough, and we're starting to see it. Survivors who have dementia, people who may well just be put in train of going into a nursing home. Reinstitutionalization is a huge issue for people who are survivors of institutional abuse. Prioritization for housing, a contributory pension, a designated drop-in centre or a confidential space for survivors to meet. Funeral expenses to be covered is something that we see a lot, and the survivors have said so in this consultation. Free unlimited counselling, and very importantly for second generation survivors, that is the children of survivors, and that I would say is something to look at, because this scheme, of course, in the payment terms won't always apply to a child, even if their parent is deceased. But there is a real need to look at the needs of second generation. And the survivors in this consultation said there was a need for counselling and psychiatric services for children and grandchildren. I know that information is also very important for both survivors and their family members, education as well. Remembering survivors by way of memorials. National education is what the more than 200 women who came together as Magdalene survivors in the summer of 2018 spoke to us about, that memorialisation has to be not just about plaques or statues, but actually about making sure that this abuse doesn't happen again. Many of the women have gone on to work in the care system, care sector, and of course we're just so lucky that they wish to speak to us about what they see today that needs to be different and that is reminiscent of their experiences. So what they want is for children to learn about it in school, for young people to learn about it, for us to know about it. And so I'm involved with colleagues in Ireland seeking, by way of memorialisation, a national centre, an archival centre and educational centre where those records can be made available and where the gagging clauses are got rid of and survivors can voluntarily, if they wish to. So oral history projects are very important, information tracing for family members. And then finally, yes, one issue that came up and that seems to be something that needs to be caught before it happens with the Scottish Bill is that with the non-financial measures in Ireland, they were attached to you having already gone to the redress board. So of course there was the short deadline to go to the redress board, so many people didn't manage to get in. And then if they hadn't gotten a word from the redress board, they were also barred from everything that might come along in the future. And then you will also have people who simply do not want money for their principled reasons, for whatever reasons they have. They don't want to go to the redress board, and they still should be entitled to the non-financial measures.
Okay, I thank you so much for your time this morning, Dr. O'Rourke. That was exceptionally helpful to the committee, and I think you've agreed to have an exchange with us regarding some of the questions earlier on. We look forward to hearing that. I'm now going to suspend the live broadcasting of the committee, and if members of the committee could meet on Teams in 5 minutes to complete our deliberations for the day, that would be very helpful. Thank you very much.